Okay, so welcome everyone. It's this time of year when we are doing the review of exploring the possibilities for the appealing customs broker license examination, which took place in October 7th, 2015. And before I dive into this, I'd like to thank, as I usually do, those examinees who reached out and encouraged me to do this discussion, because if without them I would probably not do this. And of course I would also like to thank customs broker examiners who wrote this exam. Overall, I think it was pretty good exam. A lot of questions were solid, but as always, because customs laws and regulations are quite complex, some ambiguity arises from phrasing the question, from presenting the question, and because of the ambiguity, there is a possibility of misunderstanding, misrepresentation, or misperception, and this provide the room for those examinees who made the answer choice which is reasonable under the circumstances, under the regulations, to come back to the examiners, to come back to the broker management unit and say, look, we think this answer is a compelling answer under the circumstances presented. So with that said, what we have is the exam which comprised of 80 questions. Out of 80 questions, I pointed out 9 answers, or rather 9 questions, which can be discussed, which has, in my view, the basis for the appeal. Again, as you look into this, this view is my opinion only, and this opinion does not necessarily have to be taken or accepted by U.S. Customs. So before I dive into this discussion of those questions, and I'll give you an overview of what these questions are in a bit. There are 2 things that we must keep in mind, and one thing is procedure, and another one is substance. So by substance, what I mean is I'm talking about the law, the meat of the exam question which can be appealed. By procedure, I'm talking about the points that the form, not the substance, which you must conform to prior to as you prepare your appeal. I'm not going to talk about the procedure part a lot, simply because the procedure hasn't changed much in the recent years, and I talked about the procedure to some extent during the last year's appeals discussion. This appeal discussion can be found at the following link. So what you can do is, I have a website here, lawcustoms.com, and this is a general website which I use to post opinions, topics, and at the top of the page you can see there is a link to the YouTube channel, and when you go to the YouTube channel, you go to the channel which where I post the latest discussions. You go to the playlist section right there, you hit on the playlist, and then you go to the appealing customs broker license exam section. In the appealing license customs broker exam section, you see the October 2014 video. In that video, I do go into the procedural discussion a lot. So if you need to refresh, if you need to review, this is a place to go. Now, of course, customs themselves, they post the instructions on how you appeal it, and in the letter which you receive, the scoring letter which you receive from the exam, which advises you that whether you passed or not, it also tells you about the procedural steps that you can undertake to submit your responses to customs. So this is a procedure, right? Now let's talk about substance a little bit. So what I've done is, as I go into the discussion again, I will talk through this. I will talk about rationale, I will talk about the reasoning, I will try to provide the legal background, but the most important thing here is if you take this knowledge and you reduce this thing to writing. And by reducing this to writing, I'm talking about what you must do is you must create a persuasive piece of writing which meets that burden, that compelling burden of persuasion which customs examiners must accept in order to give you that point, in order to give you that score. And that point is it is either up to you to listen to my discussion, to look at your own research and put this in writing, or what I do is, in addition to talking through about the questions which I find appealable, is to take the sample. So the sample is something which I write out, and I make it available. I make it available to those who are willing to take this, and I make this available. And by taking this, you kind of adopt. If you agree with what I say, you adopt this language, and you can present it to customs that way. Now, one way it is available at this link. So what you do is, again, you go to the general exam general page, lawcustoms.com, and there is a store button, right? If you click on the store button, you will see, and again, it will be available temporarily, because the time window for the appeal is closing. It is closing at the last part of January 2016. And by the time it closes for most of the folks, there is no need. There is no need for it, so I'll just take it down. So what you have over here is, if you scroll down at the store section, at the lawcustoms.com store, you'll see there is this appeal part. And you click on it and you go through the payments, etc., and you'll get by email whatever it is, the suggested sample text, which I will be discussing throughout this lecture. Now, those are the questions which I found are worth appealing. It doesn't mean that there are no other questions that are worth appealing. It's just the ones that I looked at, and in my judgment, they are worth of taking it to customs. Again, provided that you have the score. You have the score for which you're about to argue, and provided that you are within this limit of the wrong answer choices that you have made for appeal. So if you scored half of the questions incorrectly, it's not worth for you to even look at this, because it's just waste of time. Even if customs examiners, they find that they agree with all of those questions, you will still not pass, because you are just way too below. Now, what we have is we have question 6, 12, 13, 15, 19, 20, 27, 46, and 77 here. And for some of them, the argument is no possible correct answer, for the reasons which we shall discover in a bit. For some of them, you have more than one answer, such as A or B, whereas customs examiner says the question C is correct. For some of them, you have more, like 46. In my view, you have A, C, and D, and E, where customs examiner said it's B. For some of them, you only have one. So, for example, if you picked A, then it's worthy for you to make a submission rather than as opposed to, like, let's say you picked B for this choice. Then it's not. It's just not worth bothering, right? Where customs examiners has picked C. So this is a spot where you can find the sample arguments, and I think. Oh, one more thing before we're gonna dive into this. Also, as I receive emails from examinees asking me to take a look at their sample text, to make suggestions, etc., etc. Keep in mind that to some I do not respond. To some I think it's worth responding. To those to whom I don't respond is because I literally have to deconstruct the whole thing, and it's like doing this homework all over, right? And I'm not here to do the homework for every single individual. I'm here to do the homework, generally speaking, from my perception that pertains to those questions. However, there is one question which I received from one of the examinees, which I want to touch upon, and one of the reasons I want to touch upon it is because it calls to attention to details, and another one is because I know lots of examinees who are trying to appeal. They look at previous lectures, previous customs broker exam appeal lectures that I post, and they look at it and they say, hey, look, this one looks just like the other one. So I think what I do is I'll take the rationale for that one that I discussed and apply the same rationale to this one. And there is a problem to that, because you have to look at each question on their own merits. And even little changes to the details, and this is one good example, and this is the reason why I picked it, can be a deal breaker, right? So let's take a look at the question. So basically, a person asks, I'm currently appealing question 3 for October 2015 exam, which you reviewed in your appeal video from the October 2014 exam for question 5, right? So again, immediately, this assumes that the question 3 from October 2015 is the same as question 5 from October 2014. Well, first thing is, this is not, in this case, this is not true. The question is different, and we shall see in a bit why. But let's move on. The entry summary is exactly the same from the past exam, except the CLFTA is not shown. Well, this may be the reason, right? But let's read further. At your convenience, it would be much appreciated if you could review the below and provide any feedback prior to presenting to CBP. Thank you sincerely for your guidance. So, okay. So let's try to find. Let's take a look at the exam questions, and we're talking about comparison of 1014, right? 1014 exam question 5 versus 1015 exam question 3. Okay. Now, so October 2014 exam is open right here, and it is available at the customs broker exam page. So let's scroll down to the question 5, and it talks about what is the correct value for block 39 other, right? So let's take a look at the October exam, October 2015 exam, and we're looking at the question 3. All right, here it is. It also says, what is the correct value for block 39 other? So they seem to be the same question, even if you pay attention to the values, right? Those values appear to be the same values. So except of course for the order, right? They look to be, the question looks to be identical. So the question is based on the CBP form 7501. So in 2014 exam, customs examiners provided this snippet. In 2015 exam, customs examiners provided this snippet on which answer choices should be based. So they do look the same, and as the person who was asking the question correctly pointed out, one has a provision for CL, which stands for Chile, right? So it's a Chile United States Free Trade Agreement. And 2014 exam has this agreement. So one can reason, okay, so if they're pretty much the same, but for this one, then we can apply the same rationale. What's the problem with that? Well, one thing goes, and the reason, actually the reason why you have 2014 having Chile and the reason 2015 not having Chile here is probably because some of, again, I do not know for sure, but probably because some of the customs examiners, they viewed my critique, or some of the examinees who accepted my critique presented it to customs, and they looked at it and they say, huh, yeah, this is really weird. So what's the weird part? Let's take a look. So in 2014 exam, what we have is they have an entry summary which purports the origin of those goods. And again, this is the United States-Chile Free Trade Agreement. So the country of origin, at least for the purposes of the Free Trade Agreement, is Chile, right? And then in the same line item, they provide this particular anti-dumping and countervailing duty agreement. So first thing, notice, when you have Chile under the United States-Chile Free Trade Agreement, merchandise processing fee is not applicable. So if you have Chile and you have merchandise processing fee, immediately there is something wrong. If you fill out that form, this line item should not even appear if in fact Chile applies, United States-Chile Free Trade Agreement. But there is more problems. Do you see those case numbers? So whenever you have anti-dumping duty and you need to pay anti-dumping duty fees, so in this case it would be 29.71 for anti-dumping and 12.82 for countervailing duty, what happens is you need to provide the basis or the case number for anti-dumping duty. And these case numbers are over here. So, for example, the case numbers that in 2014 customs exam, you have A, anti-dumping 533-817-000. 000 stands for countrywide rate, but if, again, this is not meant to be a lecture on anti-dumping, but basically the way anti-dumping duties are assigned, they're assigned based on a country. So if this case applies, let's say, to China, then it will not apply to Morocco. Because Morocco, even if the product is the same, right, the Morocco case number would be different. So what I've done is I made a proposition where, let's see, we're based on the number that customs examiners. So see, they have international. So the agency that one of the agencies that administer anti-dumping duties is Department of Commerce and International Trade Administration. And for this case number A533817, right? They say that the country to which it applies is India, right? So notice that customs examiners stated that it is Chile, but at the same time, the anti-dumping duty to which at least according to their own statement, according to the customs broker examiner statement, the country is India. So either the stuff comes from India and in that case, this is 2014. In that case, you shouldn't have that. Or if you have this, then you shouldn't have this. And because the question that we're dealing with deals with the assessment of fees, right? Remember, block 39 is the one that deals with fees on a CBP form 7501 other, right? And it's a fee summary from block 39. This stuff should go there, but the argument for the 2014 exam was if you have this, you can't have this, and you also can't have this, so you have nothing if you take this at the face value. So this form was incorrectly filled out. This was made in error, and Chile takes place for those of you who picked 0, and therefore it is reasonable to say 0, right? So this was the whole basis. So this was a key to the 2015 exam, and you don't have that anymore. In fact, the whole snippet that you can see doesn't tell you anything about the country other than the case number, which is India. Now, if the case number is still the same, right? And the only notice that you have is this case number, so it must come from India. You have no other conflicting information which states that this case number, which comes from India, comes from any other country. That's it. So there is no way you can dispute, apply 2014 methodology to the 2015 answer, because. Like I said, we'll look at this and perhaps we'll learn from our previous deeds and we correct ourselves, right? So this is one way. Perhaps this dialogue is a constructive dialogue because you can see that the question itself is better formed by taking this out and making sure that there is no inconsistencies, right? So now, all of a sudden, without Chile, you can have anti-dumping for India, and because there is currently, there is a GSP that can be applicable to India, which is generally a system of preference, but by and large, merchandise processing fee will still be applicable because my understanding is not all GSP beneficiaries get a benefit of waiving this fee. Only those lesser developed ones, such as Central African countries like Chad. India is not there. So this now, all of a sudden, this looks correct. So information corresponds. This is the reason why this question, which is question number 3, I don't think there is any basis to appeal it, because the entry summary, at least the snippet part of the entry summary that custom examiners provided, it looks solid. There is nothing to talk about there. So to answer, to go back and to answer a person who asked this question is, the CL is the key. You cannot take this outside of the concept, because that exception is what has driven the appeal for the similar situated question, not the same but similar situated question 1 year ago. This year is different. So in my view, there's no basis to appeal it. So I just wouldn't bother. But if you think you can, good luck. Again, this is solely my opinion. All right, so that's what I wanted to talk about as far as comments about possible appeal. But now let's dive into the substantive discussion of questions which I think are appealable for this current exam. So one of the questions, the first question, will go in the order, increasing order, right? So it's just easier to keep track of stuff. So what we're gonna have is, we're gonna start with the first one, which I think qualifies, is a question number 6. Okay. So question number 6 is a question about the MID code, or manufacturer identification code. So it looks like a straightforward question. So all you need to do is apply the methodology which is listed in the CBP form 7501 instructions. I believe appendix number 2. Okay. Let's go to that form and see what it says. So here is the form. Appendix is all the way in the back. All right, appendix 2. It's actually Arabic numeral, not a Roman numeral. So instructions for appendix 2, they provide general rules. It's pretty straightforward, mechanical, basic stuff, right? So you take first 3 letters from the first 2 words, which will form the second part. First part is the country of origin, except for Canada. Canada uses province territories, etc., etc. So it looks like straightforward question with one caveat. The question which customs examiners ask you to base your CBP, to base your answer on, and customs examiners stated that the answer choice C, so CBP answer is C for this one, is based on the invoice which they provided in the previous page. So here's basically the commercial invoice which you have to look at and analyze. So if you look at the invoice, you notice that you have a shipper exporter, Mario Foods, right? that ship Fernando's pickles. Fernando's pickles. And they ship them in 16-ounce jars. And they ship them from Mexico City, they ship them to Dallas, Texas, to an entity known as John's Cafe. So if you do your homework and you go with CBP form instructions appendix 2, you go with the shipper exporter, right? Because it is based on the shipper exporter, and you apply the technical stuff. You'll get answers here, no question. The problem is, and hence comes the reason for appeal, is with the invoice itself. So notice what you have here is you have Fernando's pickles. What is a pickle? Pickle is a food product. It's preserved cucumber, right? It's preserved in vinegar, preserved in other substances, placed in a jar and then shipped. But it is still a food product. And because it is a food product, it is subject to other agencies' requirements. Namely, it is subject to the requirements of Food and Drug Administration. So, FDA, Food and Drug Administration, has jurisdiction over this product. Now, why is that important for the purposes of this question? Well, after terrorist attacks of 2001, September 11, 2001, Congress was nervous. The country, they felt that the country was not protected enough, so they passed a law called Bioterrorism Act. Bioterrorism Act. Let's write it out. Bioterrorism Act. What that law required is to register every food establishment, every food facility. And every food facility must submit its address, its name, and later on with the passage of Food Safety Modernization Act, it is also required to give its acquiescence to inspection from Food and Drug Administration agents, and also pay if they're found to be not in compliance, they need to pay their inspection fees. So there were other things, but for our purposes, you have to have a food processing facility. Registered. When customs enforces food product, they have the system, the ACS, now ACE system, the portal itself. They require what's known as, and based on FDA requirements, because customs and FDA, they jointly enforce the food products, such as Fernando's pickles here. So FDA requires what's called a prior notice, PN. Prior notice is a number or it's a piece of information that states that, hey, those pickles are coming into this country. And you need to submit them as a part of your notification requirement to the FDA. And the only way you can get that prior notice number is if you have food facility registration number. And the only way you can get food facility registration number if you submit form to FDA, which tells your foreign food facility address. And the system is designed to match, right? So whenever you submit the food establishment, the focus is on the food establishment that makes the production of the pickles. Here, this invoice doesn't say either the prior notice number, neither the foreign food facility registration number, neither the fact that this guy is a foreign food facility or the producer of those pickles. They merely state that Marius Foods is the shipper or the exporter. They do not, in other words, they do not produce Fernando's pickles. Maybe it's Fernando factory, that Fernando food processing facility that makes it. Mario only takes the stuff and ships it. So what you have here is you have the invoice which that is not transparent according to the Bioterrorism Act, which is a federal law, which has been incorporated into the Federal Food, Drug and Cosmetic Act, also enforced by CBP and enforced by US Customs. So now what you have is you have the background which calls for the when you make the declaration, when you advise Customs and advise FDA on who the stuff comes from, you have this background which calls for the declaration of the actual food processing facility, not the guy who merely takes the stuff, maybe packs it up, bundles it up, and ships it. You need to have actual food establishment in place, right? And because of this regulatory background, you need, I would argue that you need to declare the foreign food facility, not just merely the exporter or the shipper. And because this invoice is deficient of that entity, of the foreign food facility, then it is insufficient on its face, and therefore good or the correct manufacturing identification code, which incorporates this regulatory background, is not available. And because this invoice is deficient of the actual food processing facility, there is no correct answer. If you look at other answers, they, besides C, they also not fit. Invoice is deficient on its face, and because of this, there is no possible correct answer which can be given to this question. So this would be the core of the argument, which I would come to Customs and I would propose to them the following: that this, based on this, this question has no possible correct answer, and because it has no possible correct answer, please give me the credit for this question. All right. So that's what I wanted to say about question number 6. Next on the list is question number 12. All right. All right, so we're talking about the FPNF, fines, penalties, and forfeitures world. And immediately as you come to the fines, penalties, and forfeitures world, you may take a note that you come into the realm of 19 CFR Part 171, because that's the part that deals with fines, penalties, and forfeitures. All right. So the question is, the broker, licensed customs broker, doesn't have power of attorney on file. So what would be the penalty as stated in the CBP mitigation guidelines for each power of attorney, right? So first of all, take a note. This violation, because penalty comes from alleged violations, deals with customs brokers, right? And customs brokers the penalties that deal with customs brokers, they are congressionally provided under the law or under 19 USC, United States Code, section 1641. Which that section has been taken by customs and incorporated and expanded upon in the guidelines. And the guidelines they come in the form of appendixes for that in that part. So let's take a look. Let's go to the part 171. We go to the appendixes. See, section 1641 is the appendix C. Okay, so we open it. And we go to the one that deals with powers of attorney. All right. So one section that if you have an unpaid agent, right, and the transaction is non-commercial, there should be no penalty, right? Or actually $250 penalty for the first violation. We don't have that in the fact pattern. All we have is the penalty. We have broker who doesn't have power of attorney on file, and we're looking at the mitigation guidelines. All right. So CBP examiners stated that the answer choice is C, which is equivalent of $1,000. All right. So let's check it out. Let's see if customs examiner's response is reasonable and whether any other responses can be reasonable as well. So we go to the next one. Okay, I think this is more on point. So we have subdivision A, so appendix C. It's actually appendix C5E3. So, or E2 rather, right? So let's read at the mitigation guidelines. So penalties for failure. Let me make it a little bit bigger. So penalties for failure to retain the powers of attorney from clients to act in their names. So you have to have a penalty notice, and then you have assessment amount, $1,000 for each power of attorney not on file. So probably this is where customs examiners expect you to stop and to pick the answer, which is C, which is $1,000. The problem is you can't stop because the subdivision E is not yet over, right? So you have a different section which says mitigation. And the mitigation section is a key here because it says for the first offense, you should mitigate to an amount between 250 and 500 unless extraordinary mitigation factors are present, and subsequent offenses there is no mitigation. So this is important because it breaks down customs brokers into the class of offenders. Class of offenders. So class number one is the first time doers, offenders. And of course, in the category number two, there would be non-first class offenders. So the mitigation guidelines, and CBP is asking about mitigation guidelines in general, they break down penalties by the class of offenders. You're either the first-time offender or you're a non-first-time offender. And depending which class you belong, different penalties will apply to you. Because again, we're talking about mitigation guidelines. So according to the mitigation guidelines, and we must, again, why am I going back to the mitigation guidelines? Because they are looking for mitigation guidelines. They're not looking for subdivision 1, 2, 3. They're looking for mitigation guidelines. So we must read them as a whole. We cannot just pick and choose, right? So let's read the whole thing as a whole. Let's read that this subdivision E in its totality. We established that there is first-time offenders and there is not first-time offenders, right? And if you are the first-time offender, then the violation, the penalty amount is from $250 to $500. And for non-first-time offenders, it would be $1,000 because there is no mitigation. Again, focus is mitigation guidelines. So, customs examiners in their question, when they posed this question on the exam, they did not state to which class offenders are they testing you. More importantly, it is logical. You notice that I go in the increasing order. It is logical to start with the first-time offender, not the non-first-time offender. And if you start with the first-time offender, then the question would be 250 or 500, which they did provide in the customs broker exam. Answer choice A and answer choice B. So answer choice A and answer choice B would apply to the first-time offenders under mitigation guidelines. Answer choice C would apply to the second tier, to the second class of offenders, which are non-first-time offenders, which violated the power of attorney rules. And that would be $1,000. So because customs examiners failed to provide the class, the type of offenders that they are looking for, first time or non-first time, those answers are, if not better, they're at least equal. I would argue that they're better because they start from the first time, because there is first time for everything, right? And then they go to the non-first time, right? So it's naturally it's logical to start from the first time offenders first, and then move on to the more egregious cases. So this is the reason why I would argue that A and B are applicable based on the facts provided. All right. So that's all I wanted to say about question number 12. All right. Next on the list is question number 13. 1-3. Let's see what it says. Wow. So again, it's a broker compliance question, right? So ABC Brokers has authorized its unlicensed employee Joe to sign customs documents on its behalf and has executed a valid power of attorney for this purpose. Which of the following reflects Joe's legal authority to sign documents? So customs examiner stated that the correct answer is D. Which says ABC Brokers upon request from customs must furnish proof of existence of the power of attorney. Is that the only answer, or there is other answers, or is that the best answer given the facts provided? So let's take a look. So customs examiners in the fact pattern provide two players, right? First is ABC Brokers. So ABC Brokers is what? It's employer, right? Apparently it's a customs broker. It has a license. It's a legal entity, more like a corporate entity, perhaps LLC, acting as a corporation. It has a license. And it has executed valid power of attorney for this purpose. So it has POA, power of attorney, and it's valid. So we are not, there is no question about the properness of power of attorney which ABC brokers have made out. Now, rewinding back, going back to general discussion about customs broker responsibilities, we know that in order to transact customs business, basically, very basically, you have to have three things done. First, you have to have a customs broker license, because engaging in customs business as a broker is a licensed activity. Number two, you have to have a permit. The permit can be either national or the local. The third thing is, in order to engage in customs business on someone's behalf, you have to have power of attorney. So those are three things which is a must. Now, customs examiners do not mention anything about permit, right? They do not mention anything about permit in the answer choices. They do not mention about permit in the fact pattern. So permit is not a problem here. The license is also not a problem here, with maybe one caveat, but because it issued a valid power of attorney, right? Customs examiners say ABC brokers issued a valid power of attorney. The only reason it could be valid, because power of attorney is regulated by customs regulations, and the only way they can state it's valid is because ABC is a licensed entity. If they were not licensed, the power of attorney they issued, it would not be valid. They wouldn't say that. So by definition, if ABC brokers can issue valid customs power of attorney, then they have a license. So license, again, which license? Corporate license, right? Because it comes from ABC brokers. Is not a problem, right? All right, so that's for ABC brokers. Now, what about Joe? So we have another player, Joe. So we know that Joe is an employee, right? We know that Joe, as an employee, he is an individual. He's a natural person. He's a flesh and blood. So he's a natural person. We know that Joe, because they executed valid power of attorney, the Joe can sign docs on ABC behalf. That's the cornerstone of the respondeat superior, right, doctrine, where if you are an employer, right, and you have an employee who is authorized to act on your behalf, what happens is Joe steps into the shoes of ABC brokers, and whatever Joe does in the capacity of employee, it's actually ABC brokers, not Joe who is doing it. It's done by the ABC brokers. All right. So this is important background to understand this whole story, right? So now, customs examiners, among other things, they propose the answer in B. Joe can sign customs documents without valid power of attorney. Notice the call of question, which of the following reflects Joe's legal authority to sign documents, right? So here, and this is where distinction becomes important, because Joe, to engage in customs business, he must be an employee of ABC Brokers. Does it mean Joe cannot engage in other customs business outside of his employment? There may be conflict of interest provisions, but generally no. Joe, first he can be licensed, so CBP license. We do not know that, but it is a possibility. If Joe has his own personal CBP license, then he can engage in customs business, which means he can obtain personal or individual power of attorney. Can he do that? Why not? What's the problem here? The problem is customs examiners, they are looking for legal authority, just legal authority to sign documents. And now in B they state that Joe can sign customs documents without valid power of attorney. Now, notice they talk about Joe as an employee, right? Not Joe as an individual. So Joe as an individual does not need personal valid power of attorney to sign documents on ABC Brokers' behalf. Here the question says, can Joe sign customs documents without valid power of attorney? Does Joe have a legal authority to do that? He can sign without valid individual power of attorney, because again, customs examiners in the fact pattern present two players. They present an individual and a legal entity, right? So can that alone, so we have potentially personal POA and we have corporate POA, right? If that is given in the fact pattern, then we do not need to question here, right? Customs cannot negate whatever they say in the fact pattern in the question, because this is, if this is a negation, this is oxymoron, right? So we presume that customs are logical, rational individuals who propose you with rational, logical exam question. The only other valid power of attorney which can take place other than the one stated in the fact pattern is the one for the Joe as an individual. But that is not necessary, because as an employee of ABC Brokers, he falls within the license exception, license for which is not required, and this is 111, 19 CFR 111.2. So let's go over the regulatory background real quick, just to support our theory. So we'll go to part 111. Then we'll go to, let's go quickly to 111.1, where that deals with definitions. And as you can see, quickly see, customs broker means a person who is licensed to transact customs business. And then if you scroll down, notice here, person includes individuals such as Joe, individuals or corporations such as ABC Brokers, right? So we're talking about potentially two persons here. Now, going to 111.2, which covers exceptions, which, well, it says generally the license to transact customs business is required, right? But the license is not required if you're an employee of the broker and you have the power of attorney which has authorized you to sign documents. So basically, what's going on here? You have an employer, ABC Brokers. You have power of attorney from them. There is no question that their power of attorney is valid. It's because it's stated in the fact pattern. From this follows that any other power of attorney, such as the power of attorney presented in answer choice B is not required. So that means Joe doesn't need any other power of attorney other than the one stated here, because he can sign documents as an employee based on a valid power of attorney executed by the legal entity. And because of that, this answer choice B, I argue, is a valid answer choice. And because, and there is another reason why it is the valid answer choice. Look at the call of the question. Which of the following reflects Joe's legal authority? So if you listen to customs examiners, D is the one, right? ABC brokers, upon request, must furnish proof of existence of power of attorney. All right, so let's take a look at 111.2. And we can find that phrase over here. Broker is not required to file power of attorney, but he must provide proof of its existence to customs upon request. All right, so this is pretty much a quote, copy and pasted into the answer choice D. What's the problem with that? The problem is it provides the general principle of law, but it doesn't respond very well to the fact pattern, because we're looking at the legal authority, not what he can provide to customs based on a request or not, but what he is really authorized to do, not the procedural steps which customs implies must be done. No doubt, they must be done, but that's not what the question asks. The question asks about legal authority, and the legal authority is rooted not with other valid power of attorney, such as Joe's own personal power of attorney, but with the corporate power of attorney stated in the fact pattern. And because customs examiners, they provide two players, employer and employee, it's reasonable to assume that we're talking about two different power of attorneys here. And for this reason, B presents a valid answer, a better answer, arguably, than just a copy and paste answer which is vaguely reminiscent to the call of a question about the legal authority. Whether you provide or not, you must provide, is not the point. The point is whether you have it or not have it. That's the key. That's the key of the question. All right. So this is question number 13. Argument for B. All right. Next on the list is question number 15. Okay, so we're in the entry world. Okay, this is a weird one. So you have a shipment of merchandise that reports 0.48 gross kilos. What is the reportable gross shipping weight of less than 1 kilogram on CBP form 7501 in column 30? So, so customs says A. There is no problem with A, except that customs examiners must be mindful that anyone who done any entry writing, anyone who came across, they will know that there will be rejection or some kind of error message in the system because of that. If you don't round it up to 1 kilogram under the circumstances presented, because you need to declare something. The problem with this question on a customs broker exam is the fairness, and this is the inherent fairness implies that when customs examiners ask you a question, the question must be based not on what's actually taking place on the ground, and customs should know that what's taking place on the ground very often is not based, is not what's written on the book. Sometimes things happen. There is a human factor involved. There is IT factor involved. So things can go astray. They never always go by the book. But in the world of customs broker exam, we live in this perfect world where everything is by the law. So everything is prescribed. If there is, it's not in the regulation, it should be in a directive. If it's not in a directive, it should be in a KTR. If it's not in the KTR, it should be in some other material, such as the fact pattern, which gives you the information. So, since you are in this world, in this perfect world, then based on a question, it deals with the rounding usually, right? For the gross kilo. Examiners say yes, it's a form 7501, CBP form 7501, column 30. So 7501, column 30. So naturally, if you are the examinee who sits at the exam and who doesn't have any experience with customs matters other than the books and the regulations as they are written, they would turn to CBP form 7501 instructions for this. Because they say column 430, so you have instructions which are supposed to be instructions of how to fill it in, and you go to the page that talks about column 30 and you see how it is being filled out. Okay, so we're talking, this is column 30, we're talking about the gross weight. Report gross shipping weight in kilos by all modes of transportation, so gross weight is a must. In cases of more than one value on a line item, so sometimes you have meters and kilograms, for example, in the case of merchandise which is made out of textiles, for example, you report more than one quantity. It must be provided for each line item. If it's not available for each line item, approximate shipping weight shall be estimated in the report. So we have approximate. How you approximate doesn't matter. You need to approximate. The total of the estimated should be equal to actual gross shipping weight. So even if you estimate it, you should have the actual, right? So you don't include the shipping container as a part of gross weight, and that's it. And that's it. So the instructions, they do not say anything about rounding or how you're supposed to round. In fact, if you just keyword search round in a document, you only find it one occurrence, and this is all. It's in the beginning, and it talks about the dollars, right? Reported value in dollars round off to the nearest whole dollar, right? And it actually says if total line for line is less than 50 cents, report as 0. So it's actually, if you have nothing for the gross weight, then you look for something similar. And the similar one would be the only similar and only statement about the rounding is actually says that you can round off to 0, right? On page 18 of 7501. And we're talking about column 32. So 32 says rounding off to 0 is okay. So you have no instructions on one hand. The similar instructions instruct you to have 0. What do? Can you round? Well, let's not stop there. Let's assume for a second that we we know all these other regulations. So another possible regulation to which one can turn to is the Appendix G. So let's go to the Appendix G and see what Appendix G says. And we're talking about CATER, the Customs and Automated Trade Requirements, CATER. So Appendix G, common errors. We have an error code for 42J, and let's take a look and see what it says. So 42J, ABI filers are to report manifest quantity greater than 0 and rounded off to the nearest whole number for each IT. So one says greater than 0, one says zeros are okay. But then it says nearest whole number. So we have nearest whole number rule. I'm not gonna prove that 0 is a whole number, but perhaps when you make your argument to the customs examiners, you may want to cite authority, and usually Merriam-Webster is a authority which customs tends to trust because it's generally speaking it's authoritative source, and customs themselves they cite to Merriam-Webster in their rulings, for example. So, so citing to Merriam-Webster, mathematics, a number such as 0, right? So 0 is a number. 1 can be a number, 2 can be a number, but 0 is also a number. So we're talking about, let's go back to the question. So based on this, what customs says A, but based on this, you have suggestion that, again, we're assuming that customs examiners just go straight by the book. There is no regulation that says that it must be rounded off in such a way. And if you look at the customs examiner's own statement in the answer key, you will see that they say in question 15, fractional quantities of less than 1 kilo are rounded up to 1 kilo. Notice how tricky it is because they do not state the regulation. See, here they state the regulation, here they state the regulation, here they state the regulations, right? Over here they do not say the regulation, but I can tell you that for 2025, it's 19 CFR 14625. So it's backed, right? It's backed. Here, they are not even citing to the actual source of authority. And the reason for that is because the actual source of authority doesn't provide this, right? So when customs examiners come to you and they say that you're responsible for having the following resources, and they list you the resources. And then they come to you with a question which is outside of those resources. That means it is their responsibility to provide you that resources. And if they fail to provide that resources, this is detrimental reliance on customs statement, which is inherently unfair. And because it is inherently unfair, this question should not have appeared on the exam. And because this question should not have appeared on the exam, then the credit should be given to, if not to all, then at least to those that can reasonably be construed. For 0, I just talked about the reasonable, right? Because it is the closest one. Again, we're talking about the perfect world of customs broker examination. We're not talking about what's happening on the ground or the experience of, let's say, entry writers on the ground. We're talking about people who come in who know nothing other than the book, other than what's stated in the material. And if you just rely on those materials, it's not easy, right? It's not easy for you to come up with this correct answer because the correct answer is not provided in the sources. At least not in the sources which are required for the exam. All right, so let's see. So let's see. So going back to the exam, let's go back to question 15. I think I just closed the exam. Okay, let's open it up again. All right, so fast forward to question 15. So this is the reason why I would argue that B can be based on the background of the examinee, based on the statements of customs, based on the lack of regulatory material. B can be a reasonable answer choice. At least it is arguably fair to pick B. Now, what about the C? What about 0.48? What if you just don't round? Is there a basis for you to do that? Well, what about 19 CFR 159.3? Let's take a look. So notice it has a whole provision dealing with rounding of fractions. That's based on the regulation, not on directive like CPP Form 7501 instructions. So it's a fair game if you have this info, right? All right, so take a look at the paragraph B. Except as in the case of alcohol, subject to say, if a specific rate of more than $1 per unit, duty shall be assessed upon the exact quantity of any fractional part expressed in the form of decimal extended to 2 places. Exact quantity of any fractional part, subject to compliance with the previous, in the form of a decimal extended to 2 places. That's decimal extended to 2 places. So what we have here is another analogy that there are situations when the exact quantity expressed in the form of decimal to 2 places is acceptable. Yes, it deals with a different topic. It deals with CBP Form 7501 quantity column. So we have column 30. That one deals with column 31, which deals with in column 31 you state the net quantity. In here in column 30 you state the gross quantity. In column 31 the net quantity, the duty is based upon the net quantity. So in some cases you want to assess duty based on exact number, or at least on a decimal rounded up to 2 places, right? Rounded up to 1,000th of a unit. No, sorry, 100th of the unit. So basically there is a precedent to also for the person with zero knowledge, provided that they read and they learn and they know, they show up to the exam prepared, there is basis for them also to conclude that the 0.48 is a reasonable answer. So in 0.48 is given in answer choice C, right? Based on this information, the argument can be made that not only A, but B is good and C is good, and it doesn't come from some kind of irrational irrational guess, but it is based on an analogy which is stated in the regulation and which is stated in the CBP form 7501 instructions. So that's question 15. So CBP answer A, argument for B and C. All right. All right. So let's see. This one froze. Let's try to close it and restart it. And let's try to go to the next one. Okay. So let's see if we can reopen the exam. All right. So the next question is question 19. Okay. So question 19 belongs to the trilogy of questions. And it must be read in the context, right? So let's see. So for the following question is used, the following question is used for answers 17 through 19. So according to customs examiners, if we are to the question 19 must be read in the context of question 17, right? Following question, right? So following question is question 17. So when we look at 18, we must base on we must read it in the context of 17. When we look at the question 19, we read it in the context of 17. So what about 17? 17 states, for consumption entry made on July 18, 2014, the statutory one-year period for liquidation may be extended by a port director for a period not to exceed. The correct answer is 1 year, C, right? No problem with that. What are the relevant facts here? So the relevant facts here from the 17, which we may use to help our answer in 19, is that the entry is consumption. Is for consumption. Why is that important? Because if it was, let's say, anti-dumping entry, then there would be some kind of statutory suspension applicable until the Department of Commerce issues a final order for the anti-dumping margin, for example. So that's important. That's an important fact right there. All right. So next, the entry is made. Date of entry is July 18, 2014. All right. Then the entry can be extended, but those are the two facts that we can work with, according to customs examiners at least, when we discuss question 19. So let's look at the question 19. Hence, if CBP or port director or CBP, when they speak of CBP, they talk about delegation really. So whatever customs officer on the ground does, they do it on behalf of the port director. So the term CBP and the port director, in this context, they are interchangeable. So hence, if CBP does not actively liquidate the entry in question by, and we know that it should be liquidated within 1 year, it will be deemed liquidated by operation of law. All right, so let's take a look at the regulation that that we need to be mindful of. We're talking about the deemed liquidation, right? Regulation 19 CFR section 159(11). So let's turn to our regulatory text. So we were on routing fractions, which is great because it's in the same subpart. Okay. So an entry not liquidated within 1 year from the date of entry of the merchandise or the date of final withdrawal of merchandise covered by warehouse will be deemed liquidated. So deemed liquidation. By operation of law, at the rate of duties attached, at the rate of at the rate and the amount that the duties were deposited. So basically, the rule of deemed liquidation is a rule where you don't have to do anything, you just have to sit back and relax. Customs can sit back and relax. Nothing happens. 1 year passes. Entry is deemed liquidated. Even though, if you look in the system, it's not liquidated. But 1 year has passed, nothing took place, so it's liquidated, deemed liquidated by operation of law. Even though the system shows no, it's not liquidated. Yes, it is. It's liquidated by operation of law. So that's the point here. So now let's go back to the exam question. So here is another relevant fact, right? In 19, we have CPB does not actively liquidate. In other words, they just sit back and relax. So no active liquidation. All right. So we have two relevant facts from question 17, and we have a relevant fact from question 19. Consumption entry entered on July 18, 2014, and there was no active liquidation. So customs didn't do any proactive, such as suspension or postponement of the liquidation because of the requirement for further information, etc., etc. So based on that, it will be deemed liquidated by operational law on which date? So we know that according to the law, according to the regulation, within 1 year from the date of entry. The date of entry is 7/18/2014, so 1 year from the date of entry is 7/18/2015. 1 year, based on the facts provided by customs examiners, right? Customs examiners in their answer choice insist that the correct answer for question 19 is C. July 18th, 2018. No. Based on the facts provided, it's July 18th, 2015. Where is July 18, 2015 available as an answer choice over here. 16, 17, 18, 20, 19. There is no 15. So what happened to 15, right? We know based on the facts it should be 2015. But it's not. So the argument here would be no possible correct answer. Basis for appeal, no possible correct answer. So we are within the procedural context, right? We are within the regulatory context. So, so it looks like it's all reasonable and falls in place, no possible correct answer. What goes on here? So customs examiners, when they provided instructions, what they've done is they provide instructions which are kind of vague. And this vagueness created room for confusion. And what you have here is, you have question C, right, 2018. So it assumes that in question 17, this event took place. So 1 year took place, so 2015. And then the total time for which extensions may be granted may not exceed 3 years, right? Is another part of regulation, because the maximum extensions that can be granted is 3 times, 3 years. So so that's 2015, 2016, 2017, and 2018. So assuming that this event took place, yes, the answer is C. The problem is that customs not only gave vague directions here, because they never stated that question 19 should be based on question 18. They only said the following question, not questions, is to be used when answering 19. So we only, if we follow customs directions, we only can inquire for question 17. We should cross out question 18 from the consideration totally when, again, if we follow customs instructions, right, from consideration. Another point is, even if we assume question 17 to be true, then here the question says may, right? Yes, they may, but the fact pattern didn't say that they did in fact liquidate it. If they did in fact liquidate it, then that would be something to consider. But customs really engages in hypotheticals here. So what happens here is, because of this hypothetical and because of another fact that there is no active liquidation that took place, which negates that the customs actually did grant an extension, speaks that there was nothing done by customs, and year 2015, July 18th, 2015, is the correct answer. So for these reasons, no possible correct answer for the question 19. All right. Next in line is question 20. All right, question 20. So we're talking about, we're still on the we're still dealing with liquidations, which is important because liquidations really the definition of liquidation is a final computation of duties. Yes, they can be challenged, they can be protested, but pretty much this is the end of accounting journey on the customs end. They say, okay, that's it. Those are the duties. They're accepted. That's it. We're done here. All right. So question 20. which of the following is not a valid reason for extension of time for liquidation? All right, so customs examiners say that the answer should be C. The importer of merchandise is before customs court pending litigation. All right, so to really have intelligent discussion, let's take a look at the statute, right? The relevant statute for extension of liquidation is 19 CFR 159:11. It's this, I think it's the same. We should still have it on our screen, right? 159 entries. No, that's entries liquidated by operation of law, not the extension. So we are talking about extension. So that should be the next subdivision is 159.12, extension of time for liquidation. Okay. So here we have reasons for extension for not liquidating within 1 year, for postponing the liquidation, if you will. All right, so let's take a look at the reasons. So here, as anywhere, because we're dealing with a legal text. So legal text requires attention to details. They require attention to words, because words here can make or break the answer. Here, what makes or breaks the answer is the distinction. Is the legal distinction that there is two ways to prolong the liquidation. One way, according to 19 CFR 150.12a, 1 is extension. Another way to prolong or postpone the liquidation under A2 is suspension. Notice, even though they achieve the same end, which is not liquidating the entry within 1 year, they have different terms. There is you can either have extension or you can have suspension, either or. Which means, and because the regulations break this down into the either suspension or extension, they have different, they attain a different legal meaning. And the reason for the different legal meaning is because the reasons one can obtain for extension are different than the reasons one can obtain for suspension. So, for example, extension, you can have a need of additional information for appraisement or classification of merchandise, and it's needed by customs, right? Another reason is because importer shows good cause that they need more time for whatever reasons. Suspension, on the other hand, can be either given by the court or by the statute. So this is very important distinction between the two. It's either extension or suspension. And when we read critically the call of the question, which is not a valid reason for extension of liquidation. So we customs examiners are testing on this part. They are not testing on this part, right? So immediately, if they are not testing on this part, whatever and look, they are testing on what's not, right? What's not, if you see something which comes as a suspension, it's not a valid reason. If it comes as an extension, it may be the valid reason, provided that they have the necessary backing for it. So liquidation is suspended as required by the statute, right? This is not a valid reason because we are talking about extension, right? Notice we are looking for what's not, right? So liquidation is suspended. We're talking about suspension, which is in a different category. It's like talking apples and oranges here. So A automatically falls under the answer choice which customs examiners themselves are looking for. Another one customs examiners suggest is the importer's merchandise before customs court pending litigation. Well, see, let's go back to the regulation. Regulation says the 1 year liquidation may be suspended as required by the statute or court order. Well, court order is another reason, but it's another reason for suspension. Court order is not stated in the extension. You have CBP reasons, which is the propriety of appraisement of merchandise, the value or the classification, and you have importer request provided that they have quote-unquote good cause, right? Suspension, the only time court comes in play is in the context of suspension. So C is correct, A is correct, because they are both in the realm of suspension. All right. So again, customs is looking for extension, not suspension. So A is good, C seems to be good, right? And then additional information is required by CBP, appraisement, additional information is required classification, and importer request, good cause. So B, D, and E are they fit the appraisement language, right? So B, D, and E are not the good. They are incorrect because we're looking for the one that's not a valid reason. And B, D, and E are valid reasons. Now, let's not stop there, okay? Now, we provided the statement, right, that we know that extension, there is dichotomy, there is extension and suspension. If it's suspension, it's not extension. And the suspension talks about the statutory suspension, such as, for example, the Department of Commerce suspends due to the anti-dumping investigation, or there is a court that does it, right? So let's make the argument more compelling. Okay, we established that this is good, right? This all falls within the realm of suspension, therefore it is not an extension. Now let's dive in a little bit deeper, and the reason for that is because customs examiners provided 159.51 as another reason to support their statement that this is the better answer, and of course the standard of review is compelling. So let's try to be compelling on this one. So let's take a look at 159.51. Okay. Liquidation inventory shall be suspended only when provided by law or regulation or when directed by the Commissioner of Customs. Liquidation inventory shall not be suspended simply because of issues involved therein, maybe before the customs court in pending liquidation, since the importer may seek relief by protesting interest in liquidation. So basically, what are they saying? Importer shall not be suspended simply because, I think simply because is the heavyweight here, simply because. So the last part of the section talks about the doctrine of administrative remedies, exhaustion of administrative remedies. Before you can commence a lawsuit, commence an action, let's say in a court of international trade, you must exhaust all administrative remedies. So you must file a protest. You cannot just go straight to court and say customs is wrong. You must try to settle it in the house. You must try to settle it in the house, meaning within the agency, right? You must try to do all possible to administratively resolve the issue, whatever that issue may be, and only then go to court. Otherwise, you have no jurisdiction, right? So that's doctrine of administrative remedies. But there is something else on the books. So the question is, can you go to court and ask them for extension? There are circumstances when you can, and one regulation or one statute, I should say, United States Code is 1516A, no, let me write it again. So 19 U.S.C. 15 section 1516A C2 as an example. Let's check it out. Let's see what it says before we dive further in our discussion. I'm just gonna use the unofficial one, but for our purposes is good. All right. So it's the Cornell website, legal website. So let's dive down to C. So notice here, or let me just highlight it. The United States Court of International Trade may enjoin the liquidation of some or all entries of merchandise covered by determination of the Secretary. So there is a statute on the books, there is a law on the books that says that Customs Court or the Court of International Trade, they can enjoin, meaning they say, hey, stop customs, don't liquidate those entries. And of course, if in order to ask court to stop liquidation of entries, you must file a lawsuit, right? You must commence an action, you must initiate a lawsuit. So this goes to this question of simply because, right? And customs, because notice that we talked about here, and simply because statement can be a deal breaker here. So again, attention to details is very important. So when we go to back to the question, we say the importer of merchandise is before Customs Court pending litigation period. What if it is pending litigation simply for this reason? Can Customs liquidate? I think it would be a bad faith. Okay, they initiated a lawsuit, let's liquidate the entry. The court will not be very happy if that is the case. So this statement without more, see, I think the customs examiners by purpose, purposefully, they intentionally took out simply because it's a deal breaker. But you must take this word out and come back to customs, say customs. Here, we're talking about compelling. It's not as compelling because there are exceptions to this rule. Don't forget that the simply because, such as in the context of 19 U.S.C. 1516A, can say that there is a pending litigation customs. It's a valid reason for extension of liquidation because court can say stop customs, you must extend. So let's wait and see how it plays out in the court. Well, here, statutory suspension, right? Statutory suspension, first, it's not an extension suspension, so it fits not. Second is there is no if and buts. There is no simply because, there is no 19 U.S.C. 1516A. It's just pure and simple suspension by statute, period. So because of this, there is no ifs and buts. it's crystal clear the A is a better answer than C, and therefore those who picked A should be granted credit. So that's what I wanted to say on question 20. Okay, next on the list is a question 27. Let's have a short break, and we'll come back to this in a few. All right, everyone. So question 27. Daisy Delight ice cream. So Dairy Delight wishes to import ice cream. Their new importer with a limited importing history and low rate quota for ice cream is closed. They're importing samples in shipments exceeding 5 kilos. To determine which flavor they will carry in their line and request they will carry in a line and request you to classify under HTS US 2105-00-0500, which references General Note 15. They do not have written approval or license from USDA, US Department of Agriculture. The product is of a type subject to tariff rate quota and is subject to provisions of subchapter 4 of chapter 99. And then they have a question. Which of the following is not a reason this classification can be used? Stated differently, which of the following is a reason this classification cannot be used, right? So, customs examiners state that answer E fits the bill. Tariff number can only be used when low rate quota is open, but importers have not been importing long enough to obtain a dairy license from USDA. All right, so let's take a look at the relevant facts. Okay, so first thing we have the product. Product is ice cream. And it's not just ice cream, it's ice cream samples. Second, they exceed 5 kilos. Third, the importer is Daisy Dairy Delight. So it looks like it's a private entity, it's not a government. Not a government. So then customs examiners tell us that the low rate quota is closed. So low rate quota is closed. They do not have a license from USDA, so no USDA license. They say that the samples is subject to tariff rate quota. So product in question samples is subject to quota. And they also say that they are subject to that 99 chapter. Subject to 99 subchapter 4. All right. Those is, so when customs examiners say which of the following is not the reason classification can be used, it kind of implies then if this is not the reason this classification can be used, then these are the reasons the classification can be used, right? Just based on the question posed, right? Otherwise, it's kind of hard to pick the answer. So the way the customs phrase the question is very important, because this last phrase, it implies that there is one reason that classification cannot be used. There is one reason that disallows the classification from being used, which is 2105 of 000500, while others are okay. Is that true? Is that so? So here we have to look at the details. So first we have to look at the classification itself, which is 2105000500. So let's go to the harmonized tariff schedule and take a look what the classification says. 2105 or 000500 states an ice cream described in General Note 15. So here we have GN 15 of tariff schedule and entered pursuant to its provision. So if you want to classify it as 2105 000500, you have to conform to your General Note 15 requirements. So the next step is to go to the General Note 15 of the harmonized tariff schedule of the United States. So here it is. Here's the tariff schedule, and it states the criteria for HTS US 2105000050. Whenever any agricultural product of Chapter 2 through 52, which is our HTS US number subject to inquiry, inclusive is of a type subject to tariff rate quota. So customs examiners do state that this is subject to tariff rate quota and subject to provisions of subchapter 4 of chapter 99. So this is also, customs do state that. Entries of such product described in this note shall not be counted against the quantity specified as in the quota quantity for such product in subchapters if. So here comes the list, right? So one of those things must fit the fact pattern in order for us to be able to classify it under these provisions. So we already established that two of them fit, which are stated here in Roman numeral 1 and Roman numeral 2, right? I and double I. So let's take a look at the others. So A says that you can import it if such products imported on account of the government agency, right? So we know that ice cream samples are imported by the private entity, which is the Daisy Dairy Delights. So here we have A, provision A, which doesn't fit. We move to the next one. Such product imported for the personal use of the importer. Well, we know that Daisy Delight is a business, so it's not personal. Plus, they imported for business reason, which is to samples to see how they sell, right? Importing samples. So, provided that, so it's not for the personal use, so we can stop right there. But then they go, the net quantity does not exceed 5 kilos, and we know it exceeds 5 kilos. So B is out of the question. So B is not the reason for this classification. We'll go to the next one. Such products which do not enter the commerce of US, which will not enter commerce of United States, imported as samples for taking orders. All right. So that looks like what we have here. For exhibition, display sampling, provided that the written approval from Secretary of Agriculture or USDA is presented. We know that there is no USDA license. So C is also not a good reason. Next goes to the blended syrups containing sugar. We know that the product in question is an ice cream samples. So since this is not a blended syrup, D is out of the question. Next, E. Cotton entered under provisions of Note 6. We know that the product again is ice cream, so E does not qualify. So basically, examiners provided a fact pattern where none of the provisions qualify for the General Note 15. If General Note 15 does not fit the product, that means you cannot, for whatever reason, you cannot classify it as an ice cream described in General Note 15 of the tariff schedule. And because it is not described in General 15, this HTS number is not appropriate, because GN 15 is not applicable based on the facts provided by the customs examiners. So now, since that classification is excluded, that means whatever you do, whatever you do, this classification cannot be used, period, by default, based on this, based on the fact pattern. Because fact pattern disqualified by the reasons stated in the fact pattern from this classification cannot be used, period. So it's not that we need to pinpoint the reason this classification may not be used, but this classification cannot be used, period. So whatever is stated here is irrelevant, because customs examiners in their fact pattern pretty much stated that 2105 or 0500 is not eligible. And this would be the reason why I would argue that this question has no possible correct answer. So that's 27. Okay. Next on the list is question 46. Free trade agreements. All right. So examiners ask, which free trade agreement examine whether goods are substantially transformed in order to determine whether it qualifies for the preferential tariff treatment under the free trade agreements which are listed here. Now, the buzzword here is, of course, substantially transformed. Transformed. So before we go further, we need to kind of stop and take a look at what is the meaning of substantial transformation. So I propose to turn to customs and see what customs themselves think about the meaning of substantial transformation. One place to turn to is customs rulings. Let's see. So one way to do this is go to CROSS, which is customs ruling engine. And let's pick up one ruling which provides definition on what is the meaning of substantial transformation. The ruling number is H267177. Again, there are other rulings. I just picked this one as the one which is most recent, and for our purposes, which is more or less relevant. So this ruling comes from customs headquarters. And here's what they say about substantial transformation. And they rely on a court decision, but nevertheless, whatever they say is the current state of what's binding on customs agency itself. It comes from headquarters. So let's see what they say. A substantial transformation occurs when an article emerges from a process with a new name, character, and use different from that possessed by the article prior to processing. A substantial transformation will not result from a minor manufacturing or combining process that leaves the identity of the article intact. So basically, it's the new article. So let's say you have the marker, but you only put the shape of the marker is intact, and what you've done is you put in the felt insert, and then you so let's say plastic is molded in China. It is brought into the Vietnam. In Vietnam, the felt tip is put is inserted, and then it is shipped into the United States. The question is, was there substantial enough of substantial transformation that took place in Vietnam that made it a new article, right? So, in other words, did it substantially transform the product? Well, the question is, did it become a new article, or was it a minor one, right? In other words, if you have a product which is entirely new, which is not, instead of, let's say you took plastic pellets, right, from China, took it to Vietnam and molded the shape and inserted the felt tip in Vietnam. That's substantial, right? You had plastic pellets in China, you brought them to Vietnam, and you molded them into the marker, and you made a whole new product from pure plastic into something which can be used as a writing instrument on a board. So the country of origin for this is not China, even though the originating material is China. Country of origin is Vietnam. So that's substantial. Now, what about free trade agreements? When can substantial transformation be applied in the context of free trade agreements? So let's continue on looking again to customs for their source of authority, and I'd like to bring to your attention the informed compliance publication which they make available to the trade community, and basically it's customs viewpoint on how to interpret particular rule or regulation. So this one dates back to a number of years. Let's see. This one is 2004, so it's more than 10 years old, right? But since it's still out there and it's still relevant, I think it's worth taking a look at it and see how customs looks at what makes substantial. So in other words, okay, a new article of commerce is made in Vietnam, right? The marker. But is there a more concrete way to determine whether substantial transformation took place? So one way is to turn to the informed compliance publication by customs and read their opinion about various country of origin requirements which are stated in regulations or in the HTS US. So, for example, for textiles, they have very concrete rules which say that the origin scheme for textiles and textile products exists that employs substantial transformation criterion, right? It is based on tariff shift method. So substantial transformation can be based on tariff shift method. All right, so it can be in the case of textile. What about the case in of the free trade agreements? Let's continue reading. So we have NAFTA, right? So NAFTA, United States, Canada, and Mexico, which is a free trade agreement between 3 countries, right? For goods that consist whole and part from materials from more than one country, let's say some consist from Canada, some consist from the United States, some from Mexico. This scheme employs a substantial transformation criterion, which is expressly or based exclusively on tariff shift method. So it applies to textiles, it applies to FTAs. So the next, so now let's go back to the question and read the question in this context. Now that we know more about substantial transformation, so customs are looking whether those FTAs have provision that incorporates concept of substantial transformation, and we know this whether or not those free trade agreements have those concepts of substantial transformation if those trade agreements have tariff shift provision in their as a part of the agreement. So how many do we have here? So customs examiners state that B is the correct answer. All right, so never mind B, because we're looking, there's a bunch of other ones that they provide. So they have one for Korea, they have one for Singapore, they have one for DR CAFTA or CAFTA DR. CAFTA. They have one for Chile. They have one for Panama. They have one for Peru. They have one for Australia. And so that completes the list for A, C, D, and E, which customs claims is not, they are not substantially transformed. So because they are not listed as correct answer choices. All right, so the key is there a tariff shift provisions in those FTAs which would enable us to determine if those agreements incorporate the concept of substantial transformation. So what do? We go to HTS US and we go to general notes, because HTS, the criteria for HTS US for the free trade agreements is, it can be part of separate text, but it is incorporated in the HTS US. That way it becomes a law. That way it becomes statutory. So let's pick one. Let's pick Korea, for example, because it comes first. So let's take a look at the general note, which lists Korea. Okay, so Korea is listed in the general note 33. General note 33. let's just take a quick overview. For the purposes of this node, subject to the provisions, etc., etc., a good imported in the customs territory of the United States is eligible for treatment as originating good, meaning it has been substantially transformed, under the terms of the node if a good is wholly obtained and produced, or good is produced entirely in the territory of Korea, and each of the non-originating materials is used in the production of the good undergoes applicable change in tariff classification. So this says that the tariff shift provision does exist, and its place is in the General Note 33, paragraph O. So let's skip to O. All right, product-specific rules. It starts from chapter 1 and then goes on. A change from this heading to this heading of chapter 1. If that change took place, then substantial transformation took place. The call of the question is what? The call of the question, does Korea FTA provide for substantial transformation? The answer is yes. The substantial transformation based on the tariff shift method is incorporated in the Korea-United States Free Trade Agreement in the General Note 33.0. All right. What about others? I'm not going to go through all of them, but like I did with Korea, all I'm going to say is that all of the tariff provisions, all of those free trade agreements which are listed, they do have tariff shift provisions. Therefore, all of this agreement that customs examiners provided, they do provide rules for substantial transformation. Real quick. So, Chile would be General Note 26B. No, 26N. Panama would be General Note 35O. Peru would be General Note 32N. DR CAFTA would be General Note 29N. What else? Singapore would be General Note 25O. What else is left? Australia, General Note 28N. Okay, so if you go to the harmonized tariff schedule and you look up those notes, you find the provision for substantial transformation based on the tariff shift method. Now let's go back to the question. So the question is, which free trade agreements examine whether goods are substantially transformed in order to determine whether it qualifies for preferential free trade agreement? All of those agreements, which customs claims are incorrect, have substantial transformation provisions. And I just pinpointed all those notes. So my argument is, whichever one you picked, all of them should be good. So my argument is A is good, C is good, D is good, and E is good. Since customs examiners say B is correct, I decided not to go into those, but I just provided you with the legal background for this. So the argument is that all those that customs left out, they do qualify for substantial transformation under the tariff shift method. So that's 446. All right. So that's it. Thank you all and good luck.